Good afternoon, everybody. I'm your host, the Supreme Litigant, and I'd like to welcome all of y'all back to Smart Loc TV. Before I begin, you know the routine. If you haven't already, please go ahead and hit that subscribe button and that like button. I'll give y'all a second to do that. All right, let's get to it. So, what I want to talk about in this video, I'm not sure if y'all remember, but I posted it in the community section on my channel. And I've mentioned this in my video. What they are doing, y'all, this is what they're doing. They are creating administrative agencies, and they are investing quasi common law jurisdiction and equity jurisdiction in these administrative agencies. And they are calling these agencies courts. They might call it, like if you're in Atlanta, Georgia, or something like that, they might call the court I don't know what the county. I don't know what county Atlanta is in, but I'm gonna give you another example. I think Pensacola is Baldwin County, so they might say Baldwin County Court or something like that. But it's really an administrative agency because they're in there enforcing statutes and they're following statutory procedures. That's what they're doing. So I want to read y'all this case. Now, this is a case right here from Alabama, 1955, where the legislature or somebody in the House of Representatives wrote the Alabama Supreme Court and asked them a question. And this is the question right here. Does said bill propose a law establishing a court of general jurisdiction at law or in equity, or both, contrary to the provisions of Section 139 of the Constitution of 1901? See, they're trying to make sure that they're not violating the people's law, because the Constitution is law. The people wrote the law. The Constitution is law. The people wrote the law. You are sovereign. You can make law. They don't want to tell y'all this, though. But anyway, this is what they're talking about right here, Section 139, right here. So let me ask y'all this. If the sovereign people of Alabama have already done this, why is the legislature trying to do this? Just ask yourself that. Why are they trying to do this? If the sovereign people of Alabama have already wrote this and have already made this decision, why are the legislature, let me rephrase that, why is the legislature doing this? Just ask yourself that. So I'm going to read y'all this case. I'm going to read y'all this case and another case. I'm not going to read the whole thing. If you want to read it, I suggest you do. Here's the case citation right here. That's the case citation, or you can find it right there. Those are the case citations. Let's see. I'm gonna start. I'll read it a little bit, just a little bit more than I was, just to give y'all an idea of what the case is about. In reply, we beg to advise that House Resolution Number 5 requests the justices of this court to render a written opinion as to whether or not House Bill Number 101 would, if enacted into law, violate Section 139 of the Constitution of Alabama, 1901. House Bill Number 101 proposes to create a law and equity court for Winston County, Alabama. This is a statute, just to let y'all know. So basically, the legislature, they've already written a bill, and they're trying to create a law and equity court for this particular county. Okay, and they're using statutes to do this. They're trying to create it via statutes, and in those statutes, they have told this so-called Winston County court, or law and equity court for Winston County, they have told this court what it can and what it cannot do. That is an administrative agency because they are following statutory procedures and they are enforcing statutes. That is what they do. And administrative agencies are a part of the executive branch of government. So if you don't know what an administrative agency is, I'm going to stop right here. An administrative agency is the Department of Human Resources. In other places, they call it Child Protective Services. An administrative agency is the Department of Motor Vehicles. It's the DOJ. It's the CIA. It's the SCC. It's the DMV. It's the police department. It's the sheriff's department. Administrative agencies are a part of the executive branch of government, and they follow statutory procedures and they enforce statutes. Statutes are not laws, statutes are public policy. On to the next. Let's see. House Bill number 101 proposes to create a law and equity court for Winston County, Alabama, and abolish the county court for the aforesaid county. The proposed law and equity court shall be a court of record. The bill grants to the proposed law and equity court jurisdiction over all matters triable in the county court and concurrent jurisdiction with the circuit court in civil matters and in certain enumerated equity proceedings. Let's go down a little bit more. Appeals in law and equity cases may be taken directly to the Supreme Court of Alabama or to the Court of Appeals. Appeals in criminal cases may be taken to the Circuit Court of the county. Let's see. The specific question asked by the resolution is, does said bill propose a law establishing a court of general jurisdiction at equity or in, let me rephrase that. I'm reading too fast like I always do. Sorry about that, y'all. Does said bill propose a law establishing a court of general jurisdiction at law or in equity or both, contrary to the provisions of Section 139 of the Constitution of Alabama? To this question, we answered no. Sorry about that. To this question, we answered no. Section 139 of the Constitution of Alabama, 1901, provides, I'm not going to read all that. Y'all can read that if y'all want. I'm not going to read that. You can pause it and just read it. I'm going to skip on down. Section 139 of the Constitution of, as aforesaid, does not prohibit the legislature from creating the law and equity court set forth in the proposed bill. The law and equity court, which will be created by the enactment of said bill, will not be a court of general jurisdiction within the meaning of Section 139 of the Constitution of 1901. So, general jurisdiction is this. They hear all cases, whether the case is in equity, at law, maritime, or admiralty. That's what general jurisdiction is. So basically, that section of the Constitution prohibits the legislature from trying to act as if they are sovereign, or so to speak. In other words, what I'm trying to say is it prohibits the legislature from creating another court of general jurisdiction that is virtually I'm not going to say superior, but is virtually identical to the courts the people have already created. It prohibits them from doing that. It is to be noted that the court proposed to be created by House Bill number 101 Supper has jurisdiction which is limited. It's limited because it's in the statutes. Courts of general jurisdiction, their jurisdiction is not limited. They can hear all types of cases. Section 2A of the bill provides that the court will have exclusive jurisdiction of matters triable in the county court under the general laws. Obviously, this excludes the trial of felony cases because county courts have power to try misdemeanor cases only under the general law. Blah, blah, blah. There's something else in here that stood out to me. I'm trying to find it. I'm going to read a little bit more. I should find it because they're drawing some type of distinction here between, it seems like it anyway, but when I find it, I'll let you know about it. Section 2 of the House Bill number 101 grants unlimited jurisdiction to the law and equity court concurrent with the circuit court in all civil matters, but as to suits and equity, the law and equity court's jurisdiction is limited to the granting of divorces, suits for separate maintenance, and the awarding of alimony, and the effecting of property settlement in connection with divorces and cases involving domestic relations or the custody of children. That's what it's limited to. It cannot do anything else other than that. That's an administrative agency, by the way, y'all. And let me elaborate a little bit more on administrative agencies. All three branches of government are administrative agencies. The reason why they are administrative agencies is because the people created them. The people wrote the law, which is called the Constitution. Okay, and what the three branches of government are doing is they are administering, they are enforcing the law of the people. That is why all of them are administrative agencies. Every last one of them are administrative agencies, and the only one who can abolish all three branches of government is you, the sovereign people, because you're sovereign. The sovereign writes the law. That's why it's called public. That's why statutes are called public policy. They can't write law because they're not sovereign. They're quasi sovereign. They can't write law. If you disagree with that, let me know. Show me the case. Cite me the authority. On to the next. In the case of Cherokee County versus Savage, it was held that the Cherokee Law and Equity Court was a statutory court of record within limited jurisdiction. Let me rephrase that. Was a statutory court of record with limited jurisdiction. Further, that Further, that the creating of said court was not violative of Section 139 of the Constitution. Comparing the jurisdiction of the proposed Law and Equity Court of Winston County with that of the Cherokee Court. Boy, I'm so dyslexic, y'all. I'm sorry. I'm sorry. With that of the Cherokee Law and Equity Court, it is apparent that the criminal jurisdiction of the Winston County Court is more limited than the criminal jurisdiction of the Cherokee County Court. The Cherokee Court has jurisdiction of all crimes except capital felonies, whereas the Winston Court will have jurisdiction of misdemeanors only. In equity, the Cherokee County Court has unlimited concurrent jurisdiction with the Circuit Court. Just pay attention. Look, y'all, why are they reading these? Cherokee County Court, Circuit Court. If y'all hear, the Circuit Court is the county court. So why are they wording this as if these are two separate entities, or so to speak? They're not the same. They're not the same. And when they say circuit court, notice that these are in lowercase. So when it's in lowercase, they're speaking generally. They're not talking about a specific court. They're talking about basically all the circuit courts in Alabama, or at least the circuit court within that so-called county. But when you see right here, Cherokee County Court, that is an administrative agency. I don't care that they call it Cherokee County Court, because it was created by a statute and they're following statutory procedures and they are enforcing statutes. I don't care if they call it a court. They could call it the Supreme Court of Cherokee, of the sovereign nation of all of the worlds. If they are in there enforcing statutes and following statutory procedures, they are an administrative agency. Doesn't matter what they call it. Anyway, this court right here, the circuit court, lowercase, blah, blah, blah. This is the court that was created by the people. This is the court that was created by the legislature. That's at least that's the distinction that I'm drawing from this case. And if you disagree, or if I'm making an error or something like that, just let me know, because I'm still studying this stuff. But anyway, in equity, the Cherokee County Court has unlimited concurrent jurisdiction with the circuit court, but the equity jurisdiction of the proposed Winston County Court is confined to the matters above enumerated. So let's go down here. It is plain, therefore, that both at law and in equity, the proposed Winston County Court has a more limited jurisdiction than the Cherokee Court. And this court has decided that the latter court was not a court of general jurisdiction within the meaning of Section 139. Accordingly, the legislature would not be prohibited from creating an inferior court in and for Winston County. As stated in Ex parte Pruitt, blah, 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 the legislature has the unquestioned power to vest in inferior courts of statutory creation any of the powers or any portions of the jurisdiction of the chancery or circuit courts to be exercised concurrently with those courts if the latter are not completely and are constitutionally supplanted. Since the proposed court is not a court of general jurisdiction, the bill is not offensive to Section 139 of the Constitution, 1901. Okay. Now I'm gonna read y'all some of this right here. This right here, what I'm about to read y'all right now, ex parte Graham. I read some of this. I read about 15 or 20 minutes of it. This is a pretty good case. This is a really, really good case. If you're in Alabama, you need to know this. The juvenile court is not a court. It is an administrative agency. And in fact, all of them are administrative agencies. If they're in there enforcing statutes and following statutory procedures, you are not in a court. You are in an administrative agency, which is a part of the executive branch of government. And that administrative agency is exercising quasi-legislative and quasi-judicial authority. The county is an administrative agency. The city is an administrative agency. They are all administrative agencies. The parole board is an administrative agency. The Department of Motor Vehicles is an administrative agency. They're all administrative agencies. The food, when you go and apply for food stamps, Social Security, welfare, all of that, the Social Security Administration, they are all administrative agencies. Every last one of them. They're all administrative agencies. I'm going to read y'all some more of this. This video is going to be hopefully not too long, but y'all just please bear with me, because I'm about to take y'all to school. The legislature has the power to invest in courts of statutory creation any of the power. I already read that. But anyway, the juvenile court, under the provision of Chapter 7, Title 13, Code of Alabama, 1940, has concurrent jurisdiction with the circuit court to hear and determine all cases involving the custody of dependent and neglected children under the age of 16 years. Let's go down. I'm trying to see if I can find it. Y'all give me a second. They're going to explain to you what an inferior court and what a superior court is and how they are created. Let's see. I think it's this one right here. I'm gonna start right here. This is where it is right here. The first important question here is whether the Law and Equity Court of Franklin County is a county inferior court within the meaning of Section 3, Title 62, Code, blah, blah, blah. That question cannot be solved solely from the language used without reference to legal history relating to inferior courts. So they're going to cite cases. They're going to go back in time. They're going to read some cases. In every constitution of Alabama, there has been a provision for inferior courts. Section 139. The Constitution of 1901 made provision for inferior courts in lieu of justices of the peace. Let me see. The Constitution of 1901 made provision for inferior courts in lieu of justices of the peace courts in certain circumstances. Section 168, Constitution, blah, blah, blah. Questions first arose as to whether certain county courts or city courts in which were vested a part or all of the jurisdiction of circuit and chancery courts were inferior courts authorized by the predecessor of Section 139 of the Constitution, 1901. Originally, provision was made for a Supreme Court, circuit courts, and such inferior courts of law and equity to consist, etc. Later, the Constitution included chancery courts and courts of probate. Let's go down a little bit more. This is where it starts getting good. The question arose as to whether county or city courts vested with the power and jurisdiction which were traditionally exercised by the circuit courts at law and by the chancery courts in equity were inferior courts of law and equity within the meaning of those constitutional provisions, respectively. The case of Nugent versus State, 18-521, there's the case citation, was the first to be considered. It related to the City Court of Mobile. The legislature created it first as a county criminal court. So this, how can you create a city court as a county criminal court. You can do what you can do what you they can do whatever they want. They can call it whatever they want. But when the judiciary steps in, they're gonna correct them and say, "Hey, look, you can't do that. This is unlawful. You need to go back to the drawing board because obviously y'all don't know what y'all doing. Y'all need to go back to the drawing board and come back with something else because this is unlawful." The legislature created it first as a county criminal court with full criminal jurisdiction, whose judgments were reviewable by the Supreme Court in the same manner as those in the circuit courts. First off, in a city, the superior court or circuit court is the highest court in that county. So any type of municipal case should go directly to either the circuit court or a district court within that county. Anyway, later its jurisdictions was enlarged. No provision was made for review of its judgment by the circuit court, but they were reviewable only by the Supreme Court. It was contended that it was not an inferior court authorized by the Constitution to be created and therefore could not withstand attack. Like I just said, this court made a very careful study of the question and defined an inferior court as one whose judgments and decrees are subject to review by a higher court, and its inferior designation did not depend upon the extent of its jurisdiction. The court held that when the judgments of a court are reviewable by the Supreme Court, it is an inferior court, although it may have had the same jurisdiction as the circuit court and chancery court. Y'all see what I'm saying? This is why you need a constitution. You got to put these people in check. This is why you need a constitution. You got to put them in check. You got to check them because they just don't know what they're doing. And this is why I think all the people need to just not go to work, and all of them just need to come together and just rewrite all of their constitutions for every so-called state and change all of the whatever you don't like that your public servants are doing, you need to just ban it in your constitution. That's what you need to do. The question came up again in Ex parte Roundtree, 51 Alabama 42, with reference to Law and Equity Courts of Morgan County. This court referred to the same provisions of the Constitution to determine whether it was an inferior court as authorized by Section 139 of the Constitution. Speaking through Brickell J., so it must be Justice Brickell, it made a scholarly research again and found as follows. The division of courts recognized at common law was superior, or courts of general jurisdiction, and inferior, or courts of limited jurisdiction. Superior courts derive much of their jurisdiction from the common law. Equity, at law, ain't no statutes in neither one of those. Inferior courts derive their whole existence and jurisdiction from statutes constituting them. In other words, from statutes creating them. Hence, notwithstanding, boy, I'll be reading so fast, I'm sorry. Hence, nothing was intended to be without the jurisdiction of a superior court, whether of appellate or original jurisdiction, except what appeared to be so, and every presumption consistent with the record was indulged in favor of regularity and validity of their judgments, while of inferior courts, no intendment was made favorable to their jurisdiction, and a conformity to the law of their creation must have been disclosed by their records. Let me see. I'm going to read a little bit more. Such was the only division of courts at common law into superior and inferior. It followed from the character of jurisdiction the court's exercise, and not from the subjection of the court to the appellate power of another tribunal. In this last sense, all courts of original jurisdiction are inferior to a court exercising over them appellate power. This court has all the elements and all the instrumentalities of a court of record of general jurisdiction. within the territorial limits prescribed in its jurisdiction, in dignity, machinery, in officers, and process, co-equal with the circuit court. It can be termed an inferior court only because the eighth section of the statute creating it subjects it to the appellate and supervisory jurisdiction, which this court can exercise over the circuit courts and courts of chancery. As above indicated, uncontrolled by the judicial exposition this clause of the Constitution has received. Should I read all of this? I think I'm gonna stop. I'm gonna stop probably right here, y'all. Let me see. Hold on, give me a second. I'm gonna read the rest of this by myself, but I'm gonna stop right here for y'all, and I'm gonna read the rest of this. Let's see. Where was I? Right here. I would incline to the opinion that the General Assembly could not establish this court, that it is not an inferior court within the meaning of that term as used in the Constitution. The question was subject to deliberate consideration in Nugent versus State, excuse me, and it was declared that a court, the judgments of which were subject to revision by a higher court, was an inferior court within the meaning of the Constitution. That it is the relation the court bears to the superior tribunal, and not the character or extent of its jurisdiction, which is contemplated. The conclusiveness of this decision has never been questioned. It has been repeatedly acted on by the General Assembly and acquiescence by this court with full knowledge of it. The same provision in the same terms are incorporated in the present Constitution. We are not at liberty, therefore, to depart from it and must pronounce it within legislative competency to ordain and establish an inferior court cloth with the jurisdiction the statute confers to this court. So I think that's all I'm going to read. So the long story short, what they are doing, again, y'all, I'm going to repeat this. They are creating administrative agencies via statutes, and they are investing quasi common law and quasi equity jurisdiction in these administrative agencies. And they are giving these administrative agencies equitable powers, but these powers are limited. They can't just let them do let me rephrase that. They can't just let them do everything that a court of equity does or everything that a court of law does, because why would you need that anyway if the people have already created one? Just why? It makes no sense to me unless they're just trying to be more controlling and more tyrannical, if you ask me. Anyway, child support, that's an administrative agency, an administrative court. It's all administrative. They're all administrative agencies. Admiralty courts are civil law courts. Civil law is statutory law. The nature of the action is admiralty. They're enforcing public policy on people. They're filing lawsuits against people, and they're suing people. That's what they're doing. I'm gonna be studying equity a whole lot more, so y'all can just get ready. I got a whole bunch of stuff for y'all. Before I end this video, if you haven't, please again go ahead and subscribe to my channel and hit that like button. I really appreciate it. The Supreme Litigant is out. Peace.